I get my opening now.
Are you gonna, we gotta get the jury in first. Yeah, okay. You may be seated. Jefferson County Court Law number 2 is back in session. The court is in session. The clause number 25 CCCR 0354. Case is style of state of Texas versus Don Randall. Let the record reflect that Ms. Randall is present in court with her attorney, Attorney Wright Kimler. Let the record reflect that the state is present with Assistant Criminal District Attorneys, Attorney Farron Nixon, and Attorney Cornelius Williams. Let the record also reflect that the jury is now present and seated in the courtroom. State, are you ready?
State's ready, Your Honor.
Okay, defense, are you ready?
Great.
Now, on yesterday, the state rested its case, and Mr. Kimler, would
Okay.
you like to proceed? You'd like to proceed
Yes.
with your opening statement?
Yes, sir. Thank you. Please, court. Please.
Yes.
I give my opening statement to the right case. The law provides that the person cannot be required to take a stand, not to testify, and individual not take a stand. The court will instruct you that you can either consider that in any way, or form, or against them. In this particular case, Ms. Randall is elected to take the stand in her own defense, so you'll be hearing from her shortly. It's important to realize, even though she's taking the stand and testifying, the burden still remains on the state to prove their case beyond a reasonable doubt. It does become an issue once a defendant takes the stand. If we believe more, it's still the burden pressed on the state of beyond a reasonable doubt. The defendant's testimony is there to contextualize and provide a framework for you to further evaluate the burden of the state, whether they've met the burden of proof beyond a reasonable doubt, whether the defendant's testimony aids you making that determination, but it doesn't somehow shift the burden on the defense in any way because of the test such that it's not appropriate to put the weighting evidence and actually still see the burden still remains on the state. Your Honor, with that, I'll call Ms. Randall to stand.
Okay, Ms. Dawn Randall, would you please come forward? Now, Ms. Randall, would you please raise your right hand? Ms. Randall, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Randall, you may put your hand down. You can take the witness stand, and you can adjust the microphone in the chair. You may proceed.
Would you identify yourself by stating your full name and spelling your last name?
My name is Dawn Randall. I actually just got married, so it's hard to die, but it's RANDLEBAWN.
You have a middle name?
Michelle. MICHELLE.
And what's your date of birth?
6/16/86.
Ms. Randall, how are you employed?
Work for BISD. I am cancer support specialist / behavior.
What do you do? What's the nature of your job with BISD?
I am ISS teacher.
I'm sorry?
ISS teacher.
ISS, that's being the in-school suspension program.
Correct.
What campus do you normally work on?
I work at Benson Middle School,
And how long have you worked at Benson Middle School?
5 years.
You ever been convicted of a felony?
Never.
Ever been convicted of a misdemeanor crime of moral turpitude?
Never.
What's your educational background?
High school diploma
From where?
from Westbrook.
What year did you
Class
graduate?
of 2004.
Any vocational or college training?
None.
You have a certificate, teaching certificate from Texas?
Like a teacher's aid certificate. Yes, sir.
Okay. And that's in good standing, right? You're still working?
Yes, sir.
You've had to have an ankle monitor for the last 8 months, is that right?
Yeah.
And you've maintained that successfully or in accordance with the court's order? That's part of your bond conditions, right? You understand why you're here today, what's going on, jury trial,
I do.
go back and hear a little bit and determine whether or not the state's met their burden of proof beyond a reasonable doubt. The day in question, do you recall that? When this is allegedly all happened, do you recall that day?
Yes, sir.
What, how did you, let's just start from the beginning. How did you begin that day? What did you do?
Got up this morning, I dressed and was that's my route to work.
And where do you live, or where were you living at the time? And describe your route as well, from your route, where you lived, the route that you took to
I
this.
go from West Linwood, I go to Stilton, from Stilton I go to Concord, from Concord I go all the way down Delaware, then I turn on Lucas to Calder, all the way down to Major, and make the right on Eldridge to go to work
And where's Vincent located?
on Eldridge Drive.
On Eldridge? And do you park on campus, or where do you park when you go to?
Okay,
And so this particular day, you were headed towards campus to go to work, is that right?
correct.
Now, is it a felony to possess a firearm on campus grounds?
Correct.
And does that include in your vehicle? Do you carry a firearm on school grounds?
I do not.
And I guess there's signs, and everybody knows if you possess a firearm on school grounds, that's a felony offense, right?
You cannot have no weapons on premises.
Describe for the jury the events of that day when you were traveling to work to Vincent that day. What happened?
It was traffic that day for some reason. It was traffic, bad traffic. As I'm coming down Delaware, when we get to the light of Delaware and Calder, traffic kind of stopped. So I blew my horn. And when I blew my horn, the people in front of me, they pressed on their brakes. So after that, I blew my horn again. He pressed his brakes again. And from there, he just sat there. So therefore, when he just sat there, he didn't move. And traffic was still going. They had a big old gap in front of him. Traffic was still going. So I blew my horn like, can you go, please? And then when he did go, I turned to breathe. I'm like, this is, it's gonna be a bad day today. I already see it. So as I'm doing it, when they're in front of me, Mr. Hallmark and his wife there in front of me, he proceeds to get out his car and was talking to me crazy, waving his hands, doing all types of crazy. And he approached my vehicle. When he approached my vehicle, I politely put my window down and said, "Get away from my car, get away from me." And he was still talking crazy. So then I got out of my car and I said, "Get away from me, get away from my car, please. I'm not bothering you, get away from my car." And when I got out of the car, he shot out running. And I literally went to work. I did not follow him or anything.
You proceeded to work that day?
Proceeded straight to work. I
Did you
worked at 8:05.
Okay.
And from that day, I had a field trip that day with the kids at the career center. And that was it. I mean, I had a normal work day. Nothing else.
Did you ever follow them or chase them or anything like that?
Not one time. I don't know where that come from.
Did you get a call from the police?
The detective called me,
And did you,
like maybe almost a month or two later. I hadn't forgotten about it, honestly. And when she called, she was questioning me and I answered her questions,
okay, you answered her truthfully,
truthfully.
and that's the last you heard until you got a warrant?
Correct. I didn't even know I had a warrant.
How did you find out you had a warrant?
I was in Las Vegas on my marriage. And my cousin called me and she said, "Hey, I have a friend that's a police officer and he says you have a warrant." I said, "A warrant?" I said, "No, I paid my tickets. I don't have no warrant." Like didn't even know it all. And so I could have went to jail in Vegas without knowing it because it was just from the airport, anything. So once I got back home, I was at work when I went to work that Monday, And that Monday, the detective came to arrest me at my job,
She got arrested at work.
at work.
And then went to jail.
Went to jail, had to bond in and out, and then wait to come to court, and then to come to court to get a ankle monitor put on my leg that cost a fortune.
Objection, Judge, I mean, what's the point of having an ankle monitor and from the cost of that? That's not good.
Objection sustained.
We will leave off there. And how long has the case been pending, you know? 7 months? More?
Since
6?
April, this whole year.
Yeah, okay. That's what.
Mr. Williams? Okay.
Good afternoon, John.
Good afternoon, Ms. Williams.
Ms. Brown, what time does, Vincent school start?
School started-
7:30?
No, at that time, school started at 8 o'clock.
You just told the members of the jury there was a lot of traffic that day, correct?
It was, I was late, I got there for the time.
You made it at 8:05. I'd like to show you what's going to be marked displaced exhibit number 5. You recognize station exhibit number 5?
Please,
You do not? Can you describe the cost of the members of the jury, that Mr. Hallmark got out of?
I didn't know it was a white SUV. He said yesterday it was Infinity, that's how I knew what it was from yesterday.
You saw station exhibits, number 4, correct? So that was your car that was captured with the floss note?
All right.
Now, isn't it true, like in the statement that you gave, Detective, Wilson, that you in fact told her, that you stayed in your car?
You know,
But now you freely admit that you indeed got out of the car, correct?
when you came to my car.
You got out, correct? And you got out of your car, it was over in the circuits, correct?
Great, I was threatened, I felt threatened.
You felt threatened, but you said at no point did you ever follow that car,
I
correct?
did not follow the car at all.
But the way in which you went to Vincent, you go to Vincent Middle School through the circuit,
I stated when I told you that I pulled over to the side, was literally to breathe. Cause the man was on his brakes for literally 30-45 seconds, and I'm like, what are you doing?
no, let's talk about when you actually stopped your car, you got out of your car. Where you say Mr. Hallmark got out of his car, okay?
Not at the same time.
So
He got out his car first.
where were you all when you got out the car?
You were on circuit.
And do you normally go to circuit when when your counsel asks you, how do you go to Vincent Middle School? You never mentioned again circuit.
I do not, cause I don't go that way. I told you that I stopped there to breathe.
You stopped there to breathe. Were you going up Calder Street to Vincent?
Yes, that's my route every day.
That's your route every day. But on this day, you happen to make a turn, correct? You stopped to breathe, but your car was behind the Hallmark's car when you stopped to breathe.
How would I know they're going that way? I mean,
Because
how
you
would I
were
know?
because you were following them,
Why do I
ma'am.
have to, why do I have to? follow?
Objection,
Let
argument.
me ask you this.
Okay,
I don't
hold
know.
on, be quiet.
Argument.
Okay, objection sustained.
Let me ask you this. You ever met the Hallmarks before?
Never in my life.
Never seen them before August 29th of 2004. Correct?
Great.
why would this, if you know, why would the hallmarks identify your car? Do you know why they would identify your car?
Because it was pressing on the brakes behind in front of me.
Why would the hallmark call 911? You heard State's Exhibit 3, you heard the 911 call, correct?
Correct.
And he described the very car that you were driving following them, correct?
That's what he said.
Of course, that's what he said, but didn't also Mrs. Lauren Hallmark said the same thing, correct?
His wife, she's gonna take over for him.
If you never met them and you heard them testify, because you were sitting right there, they said they never met you before.
Exactly, so what I have to chase him for?
Because, as you just told these members of the jury, because they were not moving fast enough, because you just said that you had tapped on, because they had tapped on the brakes, correct? That's what you just said. That's what you told the members of the jury.
At the corner.
Why would,
It wasn't on Delaware.
why would, we just also told the members of the jury that the way in which you go to Vincent, you go down Delaware, then you made the left onto Lucas, correct? You made the left onto Lucas, then you made the right onto Calder, correct? And now all this time, you still behind that white SUV that the Hallmarks are driving.
Because that's my route to work.
Because that's your,
Uh-huh.
because that,
Please object.
It's a question, it's not phrased in the form of a question, it's a statement.
I said, white.
Okay, could
You
re-
followed
could
the
you-
Hallmarks.
Okay, just
Yes, yes,
repeat your
sir.
question. Rephrase.
You followed the Hallmarks.
Did not.
Listen, hold on. I'm actually.
Your- When you stopped your car on the circuit off of Calder Street, because you made a right, correct? That's the
Correct.
question.
Okay,
Your car had stopped so you could catch your breath, is your testimony, correct?
Correct.
And at that point is when Tyrone Hallmark got out of his car.
Right.
Because his car was in front of you and he walked to the back of your car, correct?
He did not walk to the back.
He walked to the
He
front of your car,
walked directly to my window
to the front of your car, while you were sitting there.
while I was sitting in my car.
And you didn't get out your car.
When he came up to my car, that's when I got out of my car. I said, get away from my vehicle.
You said, get away from the vehicle, and you rummaged through like your glove compartment,
I did
correct?
not do anything.
And that morning, around 7:50, 8 o'clock in the morning, you pulled out a gun,
Did
you
not.
pointed at him, and you walked toward him and the wife while holding a gun.
Wait, I'm gonna object, that's not a question, was that a?
You walked toward the, I'm sorry, Judge. The court heard, the question is, you walked toward,
Did you?
did you write? It calls for a yes or no, Judge.
okay, just rephrase, just ask your question.
Isn't it true? It called for a yes or no question, that you got out of your car, you walked toward the Hallmarks while pointing a gun at them.
That's not true.
How did your car get behind the Hallmarks for you to catch your breath on the circuit?
Because they turned and I turned too.
But you weren't following them.
What I have to follow them for? I don't know them people at all.
But you could have instead
I
of
have
turning,
3 children.
Hold
I
on.
have no.
but there's no
Let-
question,
let-
Judge, that's non-responsive.
Okay, objection sustained.
You say you were going to Vincent, you were on Calder. The Hallmarks turned off onto circuit, opposed to you keeping straight, because right there to the left, you had Jack's, you had Seafood Lovers, Jack's Packet right over there to the left. But the Hallmarks made a right, and you made a right onto circuit.
Don't come in traffic, couldn't go that way.
So you made a right, still following the
Not
Hallmarks.
following them at all.
You just happened to arrive behind the Hallmarks.
I wasn't following them at all.
So you happen to, it calls for a yes or no question. You just by happenstance, serendipity, ended up behind the Hallmarks on circuit.
That's your word.
Did you end up behind the Hallmarks on circuit?
Yeah.
you ended up behind the hallmark on circuit after blowing your horn, as you testified on direct before the jury, you honked. Not once, correct? Not twice, correct?
He was slamming on his brakes.
Slamming on his brakes. And for the third time, you honking on your horn, correct?
Sit there.
And this is on Lucas.
No, it's not. Now, look at none of the.
Where did you-
Did
so-
not happen on Lucas Castle.
So you started blowing your horn after the hallmarks turned on the circuit and you turned on the circuit behind him. Did you blow in your horn?
No, you're not listening to it.
Did you blow your horn on Calder?
Calder.
You blew your horn on Calder.
Calder.
So you're making a right off of Lucas onto Calder, headed toward the circuit.
I wasn't headed to circuit at all. I was headed to work.
You could have kept going straight out Calder. But you turned onto circuit.
I stopped to catch my breath because this man was sitting there literally on his brakes, literally on his brakes. Didn't want to move while traffic was still going. They had a big,
Yes,
his
ma'am.
vehicle, and they
Yes,
had a
ma'am.
big old gap of traffic.
Last question. How did your red/maroon SUV end up behind the Hallmark's car on circuit?
I'm driving my car.
No further questions, Judge.
Okay.
Good for you.
Okay. Okay, Ms. Randall, you may step down. Mr. Kimler, you have any other witness?
Your Honor, subject to renewing my motion previously made to defense rest.
Okay, and that motion is denied. State and defense rest, state, do you have a rebuttal?
No, sir, Judge. No rebuttal on the statement.
Okay. Okay, members of the jury, the defendant Don Randall stands charged by information with the offense of deadly conduct alleged to have been committed in Jefferson County, Texas, on or about the 29th day of October 2024. To this charge, the defendant has entered a plea of not guilty. Our law provides that a person commits the offense of deadly conduct if she recklessly engages in conduct that places another in imminent danger of serious bodily injury. So that you may better understand the nature of the offense with which the defendant is charged, I now define certain terms and words. A person acts recklessly or is reckless with respect to the result of her conduct when she is aware of but consciously disregards a substantial unjustifiable risk that the result will occur. The risk must be of such a nature and degree that it disregards constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss, impairment of the function of any bodily member or organ. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant Don Randall did in Jefferson County, Texas, on or about the 29th day of October 2024, recklessly engaged in conduct that placed Tyrone Hallmark, hereafter styled the complainant, in imminent danger of serious bodily injury, namely by pointing a gun at him, you will find the defendant guilty. Unless you find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question a bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced in the evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a full person, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page of the charge is the verdict form, and it has two parts. You have a top or a bottom. Now, it basically states that we, the jury, find the defendant not guilty as charged in the information with deadly conduct. And if that is your verdict, your foreperson will sign the top line where it says foreperson. Or at the bottom it states, we, the jury, find the defendant guilty as charged in the information with deadly conduct. If that is your verdict, then your foreperson will sign on the bottom line. Does everyone understand? Okay. Now, okay. Oh, okay. Ms. Mosby, could you turn that podium?
How long do we have?
I was gonna wait for him. I was gonna ask you if you, how much time do y'all need? Mr. Williams and, Mr. Kilmer, how much time do y'all need?
10 or 15 minutes.
Mr. Williams?
I respectfully ask, since we have the open and close, I respectfully ask for 20, Judge. I
20?
don't expect
Okay.
to use the entire time.
Oh, before you do that, Ms. Mosby, could you get them to put the monitor on the computer? Hold on, I think it's gonna, she has to put it on that first, before you do that. Thanks. Oh, okay, I'm gonna give you each side 20 minutes. And I will be keeping time. And Mr. Williams, you may proceed.
Thank you, Counsel. Good afternoon. Let me begin with an apology to the court. Legal counsel, Mr. Campbell, right, for the defense, and to you, members of the jury. As an advocate for justice, times I'm very passionate. If I came across indignant or disrespectful, I'm truly sorry. This was not my intention. Do not hold that against the case about the state. Now, as a prosecutor, I only have one job, and that is to seek justice within the parameters of the rules of evidence. So if something is improper, it is incumbent upon me to object, so that, in my humble opinion, that you will not be misled or facts obfuscated. But you see, Mr. Kim also has a role, and that's to zealously represent his client and to hold the state to its burden, which we warmly and forcefully embrace. We both have in common, or we must abide by, are the rules of evidence for which we are all bound. And when any of us think something is improper, we object and the court makes its ruling. Now, under such rules, I want to get this out now. Police reports are generally not admissible unless offered by the other side. Likewise, statements of witnesses, which are taken outside of court, are not admissible unless offered by the other side. That's why when we have testimony, you hear it again from the stand. We cannot have the testimony from the stand if it's consistent with with the statements which made previously. They would be barred by the rule of evidence. And generally speaking, police reports are not admissible. You will not be getting police reports. Now, as Mr. Kimber aptly pointed out, the defense has absolutely no burden. However, in this crucible of truth, when you put the state's burden to the test, they also have abilities to what? Subpoena witnesses and present the case as he did. He has no burden to do so, but he has the tools and abilities to propound subpoenas and the like. So I suspect, in his closing, Mr. Killer may say, where was X? Where was Y? Where was witness X, Y, Z, whatever? If you felt the need to contribute to the truth of this crucible, there were tools to do that. Now, the state presented its case based upon evidence which came from the stand and exhibits which were admitted. That's what's before you. That is what you must judge. And while you were listening, the witnesses, you judged their credibility, you judged their demeanor. How did they testify? What is indeed plausible, what's not plausible, what's believable, what's not believable? That is totally in your province. I suspect that when counsel addresses you, I have an opportunity to address you, that's just because we have the burden. I wanted to get some things out of the way first, and that's what I'm doing at this point. But I would submit to you that counsel will state. Do you know beyond a reasonable doubt what happened? I submit to you that you did. How do you know beyond a reasonable doubt? Contrary stories, that's not doubt, ladies and gentlemen. It's what is corroborated evidence which you have before you, but counsel will say, don't take away. Is that enough evidence to take away the person's take away a person's freedom, take away a person's right? If they are convicted, is that enough? I submit to you, ladies and gentlemen, that the very reason we are here, the very reason you are part of this crucible for truth, is on the invitation of Ms. Dawn Roundel. Her actions on October 29th brought us here today. We submit to you now, and we will submit to you again, that the facts presented prove her guilty beyond a reasonable doubt. Thank you.
Yes.
Thank you, ladies and gentlemen, for your attention. I too, apologize for the testing in there. And anything I did, offended y'all or upset you, please hold it against me personally and not my client. No, if you didn't choose me to get upset or maybe say things that, you know, might irritate you or something, so please ask you all against me and not her. Things do get contentious in trial because things that we litigated here are very important. The criminal court is not about money, it's about people's freedom and liberty. So yeah, things do get a little heated at times, and there's rules and there's disputes about the laws. But we do try to maintain decorum, and they feel a little bit short in that, and me personally in that regard, in this particular case. I do take issue somewhat with Mr. Williams' characterization or description of this process of being a crucible of truth. It's not about certainty. We talked maybe a little bit about that before now. You don't know certainty one way or the other, whether it's innocence or absolute factual validity of the allegations made against someone. You know that because many times people be convicted on proof beyond reasonable doubt standard, they've literally violated on DNA evidence that they were actually innocent of what they were convicted for. So it expects, I think it's a little bit, sets the bar a little bit too high expectations to call this conclusion. You best you have what you got and making a decision. Looking at the evidence that's been elicited and applying the standard of proof beyond a reasonable doubt, which the judge didn't define for you. You have to come up with that yourself, what that means, and evaluate the state's evidence. I like to start out in my arguments where Judge Holmes leaves off on the jury instructions, and that's what your duty is. Your duty is to see what justice has done in this case. What I would suggest to you, that's an individual responsibility each of you have. It's not a collective responsibility to return a unanimous decision, one way or the other. If you go back into the jury room, you know, it's your reason, your common sense after deliberations amongst yourselves. And you can't come to an agreement, and that's just the way it is. It's a hung jury, and there's no failure to see that justice is done by telling the bailiff, hey, we can't reach a verdict, let the judge know it's a hung jury. I would suggest to you that the only way that you really breach that duty to see that justice is done is if you surrender what you actually believe is the correct result, simply to return a verdict, that you're pressured into giving up what you actually believe to return a unanimous decision, and that would be wrong. Maybe when you saw it to jury duty, you've seen how the system up there kind of works. You're gonna take away from this a little bit of knowledge, but it's easy to get caught up in the criminal justice system, a lot easier than what a normal person thinks. We have, you know, a person that's handling this particular case is on her way to work, in the morning, and all of a sudden, 2 months later, she's got a warrant coming out for an incident. And they have to go through a jury trial, has to have an ankle monitor for 8 months as a bond condition. And she's brought into court and has to get subjected to this process on what? On allegations made by 2 individuals that are, I would suggest, be unsubstantiated and corroborated. And set against her statement, which it would, you would think would have at least the equal amount of validity in the eyes of the law of the people evaluating this because of the lack of corroboration. But yet she's the one that's charged and she's the one in there and has to defend the case. And you have to ask yourself at least ask. And so, well, looking at this, looking at the 2 different positions here, 2 different parties involved, why is one party believed and the other isn't by law enforcement of the system? What's the difference between these 2 people? These 2, Miss Randall and the Hallmarks. What's the difference that where the Hallmarks are suddenly considered credible by the state, and Miss Randall isn't? I don't know. I wish Mr. Cornelius and I would suggest hopefully maybe he can inform me of that. What's the difference? Why are the Hallmarks believed and Miss Randall isn't? I mean, she's not a criminal, at least she doesn't have any criminal history. She works at BISD, she's gainfully employed, seems to have a successful career. It's not like she's on, you know, has a long criminal history, is out on parole. And you can compare her criminal history with the Hallmark's lack of criminal history, which would seem to give them more credibility. These seem to be 2 equally credible people, 2 equally credible parties. Why is she the one that's being prosecuted? I don't know. I don't want to think that it's because Mr. Hallmark's sister is a BPD officer. I don't know if that has anything to do with it. It's one thing that comes to mind. I don't know. I'm not making that assertion or allegation, but it's out there. But for some whatever reason, of the 2 people, she's the one that has been disbelieved and has been prosecuted. Without is incumbent upon Mr. Williams and the state to bring you evidence that would convince you that she did what they say she did beyond a reasonable doubt. What have they done? They've made the allegation, they've chosen to make this allegation that she pointed at a gun. Now, gun is not defined in the jury instruction. There is a definition of a firearm, and I would suggest to you that the way the state is attempting to.
I'm sorry, I have to.
Okay.
I usually, in fact, that it's not into evidence. It's beginning to superimpose a burden going into the entire thing on the firearm judge.
I would simply observe, Your Honor, that the gun has not been defined, but the way the evidence is developed and reasonable inference the state is asking the jury to draw is that it was a firearm that was used. Not some type of gun, a dart gun, a toy gun, a BB gun, but an actual firearm, gun being firearm.
Okay, ladies and gentlemen, jury, the questions and comments of the attorney did not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. Okay, Mr. Kimley, you may proceed.
Yes, sir. Again, I would observe that the state, as the charge is made, as they chose to frame the charging instrument, they allege a gun, they didn't allege a firearm. And firearm has a particular definition in the penal code, a gun does, a gun is a generic type of assertion that's not defined in the penal code. I would suggest to you that I think what the state is going to invite you to do is to engage in speculation or a reasonable inference, depending on how you look at it, that the evidence indicated that a firearm was used. In other words, that's what makes this the deadly conduct. They have to prove that. They allege that they have to prove that a gun, that is a firearm, was used in this particular case. So where's the evidence? Was any firearm recovered? Was even Mr. Hallmark able to give you a reasonable description of what was used? I would suggest just one or two things. It's either he's making it up, he's lying about it, or he was so confused or upset when Ms. Randall pointed at him and maybe frustrated that he conflated that and thought it wasn't wrong. In his own mind, he created the idea of a firearm things that really out of panic and confusion. And that's the derivation of why that the gun allegation was made. Because there wasn't a firearm used. Again, you don't have to believe it, that it wasn't used. You just have to have a reasonable doubt about whether it was used, whether there was a firearm. In other words, you don't have to disbelieve that there wasn't a firearm. You have to have a reasonable doubt about whether there was, for this to be a non-guilty case. Ms. Randall told you that she was on her way to work. You parked on school grounds. You can't have a firearm in your vehicle. You can't possess a firearm. That's a third-degree felony in Texas. So a prohibited place along with like church, amusement parks, schools, places like that, courthouses. But it's a felony to possess a firearm. So she knows that she didn't have a firearm. But again, we're talking about, do you believe beyond a reasonable doubt that she did in order to get convicted? There's a reasonable doubt. There's the not guilty, but whether or not there was a firearm. If you want to go further, I guess, into the evidence, as far as the hallmarks, you can listen. Yeah, we'll take a little bit of effort on the 911 call to demonstrate that when that call was made, there was no indication from Mr. Hallmark that he ever got out of the vehicle. And I think that's significant when they're evaluating the case on how things proceeded, that his original assertion when he made the 911 call, he didn't mention that he got out of the vehicle. There was no indication that he was tweaking it to look like that she approached his vehicle and threatened them and left it at that. And then later on, he actually got out of the vehicle, which maybe was a little bit this closer to what actually happened. Again, you can look at all the evidence such as it is that's come in, but basically this comes down what looks like a swearing match for two different people, both of whom seem to lack criminal history and criminal predilections that would fall short, hopefully, of proof beyond a reasonable doubt in this particular case with Ms. Randall. I suggest to you that there is a failure of the state's proof in this case to convince you beyond a reasonable doubt that she did what they're saying that she did. Don't confuse a prosecutor standing up here engaging in what I would call performative histrionics, telling you what the facts are. The facts don't come from the defense or the state, they come from the witness stand, and you have to evaluate what actually are facts. Somebody standing up here and telling you what happened isn't a substitute for a lack of evidence in this case. Keep an eye on things, and I ask that you return a verdict not guilty.
And you have 15 more minutes.
Unsubstantiated. Uncorroborated. No evidence before you. Why does Miss Randall sit for you? Back when we were in Guadalajara, we questions about biases and prejudice and things of the like. But we also, you remember that question we had a showing of hands again about who are gun owners. I submit to you right now that no responsible gun owner would have dared the actions of Miss Randall. Now, you heard testimony before you
that over there, when the when the Hallmarks, when Time Low and drop their child on. It's right there on State's Exhibit 3, ladies and gentlemen. They dropped the two children off. They proceeded. After dropping the kids off at All Saints School, you heard the testimony. And listen to the testimony again. You judge the credibility of the witnesses as they sit there. They began to go down Lucas Street. And right here, under the red dot, this is what Tyler put. Where they noticed like this car. What car? An SUV. Which started to blow like the horns and everything. Right here, remember when he talked about a glance that had been a truck that could be going over here to, the truck could be going over here to what, like for Daddy-O's right before at the corner well, you remember testimony, but like there's a Daddy-O's pizza. Daddy-O's burgers that's right there on the corner. What they continue to do, then they made a right onto Calder. Now keep in mind, you have to juxtapose their testimony, right? With the testimony, of course, the defendant. They made a right turn. We see the purple dot for Mrs. Holmes. They made the right turn. But this car, one thing that we know, you want to know what the corroboration is? The corroboration is this woman behind us honking the horn. She's honking the horn. She's following so close that I can look back and I can see that she has on like an orange wig or some orange hair. Did she get out of the car? She absolutely got out of that car. Where did she get out of the car? Right here about to be turning on to circuit. But you heard her testimony, right? You heard her say, oh, she pulled over. She pulled over to calm down, to catch her breath. For what? Does that make any sense? She pulled behind them. She could have kept on going straight on to Vince. She made the choices. She made the choices, ladies and gentlemen. That is why we are here, from the choices she made on October 29th. Operation. They never met her before. Here's the car. And the time, if you look close, at the time, which is on State's Exhibit number 4, you'll see it says 7:54 on October 29th. You heard Detective Wilson take the stand and to testify. Here's your corroboration. Because she knew that she, being the defendant, when she took the stand, we have her. I submit to you that otherwise, I don't know what they're talking about. Never was there, never seen them, nothing like that. And guess what? The Hallmarks decided to make the whole thing up. No, there's your corroboration in the time. Well, that was taken. Master license plate. You know what that was? Detective Wilson, when she took that stand, therein lies like evidence. What did she do? She generated a suspect. How do you know she generated a suspect? Because she shared it with you all. She reviewed the officer's report. She reviewed the Hallmark statement. She spoke with the Hallmark. She even spoke with the defendant. Based upon that is how a suspect was again generated. Why? Because the Hallmarks did not know her. They did not know Don Randall from that day. In order for a defense argument to pass, in order for it to pass the Giggle test, you would have to believe this is the absolute greatest conspiracy against an employee of VISD who teaches over in the ISS, the in-school suspension, over there at Vincent. Everybody and the weight of the government is going to just attack her. You had a physical description of this defendant. That's too small to see. That's tiny. Lauren and Ty drops the school off in the chronology of events. You know it, you heard it. I will not belabor those points. They made a turn, as we just saw, left onto Lucas after leaving their kids at All Saints. Along the way, they encountered who? What? They encountered a red maroon SUV, which was tailgating them and blowing the horn. Once again, corroboration. not once on the horn by Don Randall, not twice on the horn by Don Randall. 3 times again on the horn. You may infer, I submit to you all, before the evidence, she was angry. She got mad that morning. So mad that the hallmarks, she kept on them. Ladies and gentlemen, this is, as I said before, this is a case of road rage. That's what it is. From our common experiences, we know how people, if they're moving too slow for us, she said that there was traffic. She said that there was a truck there. You know what? When she said there was a truck there, their traffic was backed up while she was again blowing that horn. Keep in mind, she had to get to Vincent. Look at the time when she had passed. This car is moving too slow for her. She's upset. She's in a hurry. They hear this car, I'm sorry, is tailgating her. Ty testified that what did he see? He described the car. He also saw a placard. When you go back and list State's Exhibit number 4, should you choose, you're going to see that placard in the car. Once again, detective work, this is how this matter happened. Counsel points out, where's the gun? Where's the firearm? You heard Detective Wilson. I didn't talk to her till after the incident. You know why? Or for a while after the incident? That's called detective work. That's called investigation. But you know what was happening in real time? This lady's following. He described the car. He made the 911 call. They made a turn. You heard the testimony. You judge the credibility of the witness. I submit to you that once we look at the credibility again of the witness, you have to weigh those conflicting stories. I'm going to even say this. Lies are not reasonable doubt. We use our common sense. We use our common experiences. What makes sense? Okay, what makes sense is that when Ty made that turn onto the circuit, opposed to continuing on down Calder, she made a right turn, and you saw her when she took this stand, and when she sat down and she said, upon questioning, I don't know. Okay, I turned it, but I wasn't following them. I wasn't. What is more credible? She made a turn opposed to going straight, going to, excuse me, I said Marshall, going to Vincent. She followed them. After she followed them, she did say she got out of the car, correct? Mr. Hallmark and Mrs. Hallmark, cooperation, not every copy story. Y'all be the judge. You are the exclusive judge of the facts. He said he heard a bang. Now remember, Mrs. Hallmark, y'all remember when she said, I saw like exaggerated turn, this car followed behind us. We heard a bang. I got out of the car and heard the bang. He thought his car was hit. You heard from like the gestures. He got out the car, put his hands up. The wife sees that. The wife also testified. The wife, Lauren Hallmark. She saw the defendant do this. She described her height. She described her weight. She goes back to the car. She starts screaming for Ty. Ty, she's going to get a gun. What is the corroboration? They both describe what? A black gun. Was it a pistol? You heard able counsel for defense. Was it a revolver? It was black. It was a gun. She pointed it and she turned it sideways. What did they do at that point? They jumped into that car and off we go throughout the service while the car is following her. They finally found like a cul-de-sac. The estimated beginning, a cul-de-sac. They put it through a driveway, and but during this time, there's a 911 call. They were good cop. An entire story. Call 911. You heard what was happening in real time. Ladies and gentlemen, that is cooperation. Why did they try like to flee her? Well, because after she had pulled out the gun, after hearing a sound, that is the very nature of deadly conduct. We cannot have, and the troubling point, when I say we, I mean our community, we cannot have within this community with gun owners, responsible or otherwise, becoming self-imposed traffic police that may be attempting to use, again, physical violence. We're here because of the actions of one individual, and that's Dawn Randall. Hold her to account. You can clearly send the message that this is not, it will not be acceptable, not just from, not acceptable within our community. You have beyond a reasonable doubt all the evidence to find her guilty.
Okay, ladies and gentlemen of the jury, both the state and the defense have finished their closing arguments. The case is now before you. I have to inform you that one of you, or well, one of you, well, one person on the jury will not be allowed to go into the jury room because you are an alternate. Now, so the alternate in this case is Felicia Patrice Armstead. Armstead? That's you? Okay. Now, Mr. Armstead, you'll be allowed to, you can sit out in the hallway, or if you want to remain in the courtroom, you can do that. Now, if something happens to one of the other jurors, then you would have to be available to replace them. Okay? So at this time, I have the charge. This charge will be given to the bailiff. You'll bring this charge in the jury room with you. So at this time, ladies and gentlemen, jury, would you please stand? Everyone please stand as the jury exits the courtroom and goes into the deliberation. Going to be in recess until the jury reaches the verdict. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 25 CCC Aura 0354. Case is styled the state of Texas versus Dawn Randall. Let the record reflect that Ms. Randall is present and seated in the courtroom. Let the record reflect that Ms. Randall's attorney Wright Kimber, is present. Let the record reflect that the State Assistant Criminal District Attorney Kenise Williams, is present. And let the record also reflect that the jury is not in the courtroom. I have received a message from the jury that it has reached a verdict. Will the bailiff please bring the jury into the courtroom? Let the record reflect that the attorney for the state, the attorney for the defendant, and all members of the jury are present and seated in the courtroom. Foreperson, have you reached a verdict in this case? Is this verdict unanimous? That is, one that is agreed upon by all jurors.
Yes.
Please hand the verdict to the bailiff. Now, foreperson, is the verdict the unanimous verdict of all members of the jury? Okay. At this time, I'll read the verdict. It says, we, the jury, find the defendant not guilty as charged in the information with deadly conduct. Anyone like to have the jury poll? Okay. No, so, here you go. Okay, members of the jury, thank you for the time and attention that you have given to this case. Your jury service is concluded. Now, I mentioned to members of the panel, those who were not selected as members of this jury, I mentioned to them that anytime that they're in the court, in the neighborhood or in the area of County Court at Law number 2, they can come and have a seat in County Court at Law number 2. And as I mentioned, that area you can sit in, we call it the peanut gallery, but you can't bring peanuts in here and eat because this is not the Texas Roadhouse. However, you can come and have a seat in your courtroom and see what goes on in Jefferson County. And I know that you will find that is very interesting. And I know that when you came to court Monday, you looked over the top of the door. Once you got outside, you said, oh, this is County Court at Law number 2. This is Judge Terrence Holmes' court. Well, this is not my court. This court belongs to you, the citizens of Jefferson County. So you're invited anytime to come and have a seat in your courtroom. Now, if you cannot come to court, we are on YouTube, and you can view us on YouTube Monday through Friday. Now, the bailiff, she has some letters. She's going to give you some letters in a few minutes. If you feel free, you can drop us a line. Let us know how you feel about your experience here today, and actually the last three days or 4 days. Now, usually I give the members of the jury, once jury services concluded, I usually give a handshake. However, because we have COVID in our communities, I don't just give you a physical handshake, but I can give you an air handshake. Thanking you for being here these last 4 days since Monday of this week. Now your services are concluded. The district clerk's office, if I'm not mistaken, they're closed at 4:30. So if you need any excuses, we have our court coordinators who's here. They'll be happy to provide you with a letter with an excuse. Now, make sure that you turn in your badges. We reuse those badges. And again, thank you for being here today. If you have any questions, you're gonna ask me some questions. If not, on your way out, the attorneys may want to ask you some questions. You don't have to answer any questions if you do not want to. If you want to, you can, and you can stand and stay around and ask or answer any questions that they may have. But again, on behalf of the citizens here of Jefferson County and behalf of the staff here in County Court at Law number 2, I'd like to thank you for your time and attention. So at this time, with that being said, your services are concluded. You may stand, exit the courtroom, and each and every one of you have a blessed day.
And stop. There. And
Right here. Need an excuse? Over here.
Thank you.
You are. Huh? Jury, oh.
John, I wanted to see that, get the order to get that ankle line.
Get the order.
Sure. We'll get that one.
We already have it.
Where did you put it on? Yeah, just take that order to John. It's nothing. I don't know if you could do it today. Get it done
It
today?
says GPS. The other one gonna say interlock.
Mhm. Well, she didn't, I can, you get the order, you can thank you.
This will conclude cause number 25 CCCR 0354 cases style of state of Texas versus Don Randall. Everyone, please have a blessed day.
Wow. If you file things,